Kathy. I hope you're doing well. Time for OJ. This is exactly where we left off. Talking about these tapes she made with him. The thing about these tapes is they were supposed to be for a screenplay that she was making. So the tapes were never about facts. They were about this fictional screenplay she was writing. So that's the defense's biggest deal. Doesn't change the facts of what he said. It's horrible.
Would it refresh your memory to look at the transcript?
Yes.
Could you look at the transcript for tape number 1 at page 28?
Go ahead.
Does that refresh your memory?
Yes.
And in what context were those words spoken?
This would be the context regarding the black Muslims stopping 2 suspects on the street who are black Muslims.
In terms of where that would be likely to take place?
Yes.
We could have number 14, please.
I mean, that's just the way you feel. You know, you got 200 trying to take you prisoner, you just chase this guy and beat the shit out of him.
Do you recall the context in which those words were spoken?
I remember it being said. I don't remember the context.
Would it refresh your memory to look at the transcript?
Yes.
All right, could you look at transcript number 2, or transcript of tape number 1, page 1? Does that refresh your memory?
Yes.
And in what context were those words spoken?
Officer Furman is explaining what it feels like to work on this particular mid-watch.
All right. Could we have number 15, please?
She is a female. She's a policeman in the city. And don't you ever fight or fuck around with the policeman. You do what you're told. You understand, baby?
Do you recall the context in which those words were spoken?
Yes.
And what was that?
My best recollection is it was a situation where I was asking how an officer would respond to transporting a suspect who had beaten up or hit a woman officer.
All right. Number 16?
I'm going to endorse an objection yet. I do not. Well, I don't know. Let me inquire of the court. Is this at all helpful to the court in giving any additional information over and above what it already has in defense proffers?
No, this is the person who's conducting the conversations and interviews with Detective Furman. She has unique personal knowledge as to each one of these individual situations.
What unique personal knowledge has she imparted thus far that we haven't already gotten more of in the proffers themselves and the actual transcript?
Well, at some point in time, I'm going to ask that question, but I'm letting Mr. Ullman go with what he feels is appropriate at this point.
There are a number of excerpts we'll get to in a moment where there were others present, and an additional set of excerpts where we do not have a tape, Your Honor. So I think this will be very helpful. Do we have the next excerpt?
Tonight, go on guard.
Recall those words?
They were, I need to see
think
them again. They were,
All right. Could we repeat that?
I heard it.
Just go out there. What are you going to do with some tonight? Go on guard. That's bullshit.
Do you recall the context in which those words were spoken?
I believe, yes, we were discussing fencing. It would be helpful to look at the transcript, but to my best recollection, we were discussing what it would be like to be fencing 2 officers, and Officer Furman was saying that something to the effect that even knowing fencing isn't particularly useful because that's not something that an officer would be called upon to use in the line of duty.
So when you refer to fencing, you're referring to sword fights?
Yes.
All right. Could we have the next
All right,
excerpt?
hold on. Madam Reporter, all right, we need to take recess. All right, we're going to take a 15-minute recess at this time, and Ms. McKinney, you may step down and come back in 15 minutes. All right, thank you. Epithets that the defense is seeking to offer before the jury and I'll have Mrs. Robertson file this as an addenda to the defense offer of proof.
Your Honor, what
Excuse me,
this
counsel.
list-
Excuse me.
Yes. I'm sorry.
All right, we'll addend this to the amended offer of proof. Previously, the court had ordered the offers of proof and the response sealed because of the inflammatory nature of the content. And I have decided that given the fact that we are now publicly discussing the content, that I'm going to unseal the proffer and the prosecution response, and I'll instruct my staff to make that available over the noon hour. Secondly, Mr. Ullman, over the recess I had the opportunity to sit and contemplate for a few moments, and I agree with the prosecution that the court does have, I think, ample context, having read the entire transcript with regards to each of the identified excerpts that you wish to play. However, I think that there is a overriding public interest in the nature of the offer that you're making. And I don't want this court to ever be in a position where there is any indication that this court would participate in suppressing information that is of vital public interest. I think that's already been expressed by the city attorney's office, and it's been expressed by other interested entities that this information be made public. So what I'm going to suggest we do at this point, Mr. Ullman, is that you play your video presentation to the court in its entirety without further interruption. I'll hear it again, and that'll be for the purpose of public dissemination of this information. But I have read and considered and listened to all of this.
All right. Your Honor, if we could just make one request. There are some excerpts where, for example, it refers to Officer Furman nodding without describing the nature of the nod. It refers to a ripping motion in the course of the discussion of what you would do with a driver's license, which does not appear in the transcript. We would, with respect to those excerpts, request to stop the tape and just put a few questions to...
Well, let me ask you about number 15. Mr. Detective Furman is heard to make some noises at the end of the tape, which in my, I guess, screenwriter's imagination thought he was discussing, this is where the context was, how would a police officer respond to transporting a suspect who's been arrested for assaulting a police officer? And Furman says, well, you would tell them you don't do that to anybody, any police officer, be they male or female, and then he makes some noises, which, given the context of the other tapes, I interpreted as either baton shots or something like that, gestures similar to that, which are not recorded. So if that's the context of the gestures that are being made, I don't know. So I agree with you, there may be some portions where you need to stop. But other than that, I think I understand the context.
All right.
Are we clear?
Well, could we back up into 17? Yes, we have a problem with our court reporter.
No, we don't have a problem
We don't
with
have a
our
problem. We have a
court
problem with us. The transcript simply reflects silence while the displayed portion of the excerpt is displayed, and then questions about that excerpt. If we could have a stipulation that at that point we could insert into the record the actual words of that were being displayed at the time.
Well, we are referring to by excerpt keyed to the offer of proof. The offer of proof also has the text, so the text is there. The record, I think, is adequate.
All right. And I also wanted to clarify that the list I gave, Your Honor, of the 17 instances are instances that we contend are relevant both to show use of the word and to show racial bias. But that's not
I understood
necessarily
that
a
the first time.
withdrawal of all 41 uses of the word.
All right, let's start with 17. Let's resume with 17.
Your Honor, the present format that we have on the tape is a 20-second delay between each excerpt.
That will give you the opportunity to say this is excerpt 17.
All right, and we intend to shorten that for actual presentation to the jury so that we don't have 20-second delays between each excerpt. Are we ready to proceed? This is excerpt B17.
We have audio.
We should.
Let's go with practice movements. So what do you say? And scratches my kids.
Now excerpt B18.
That's a good point.
Are you capable? 6'7".
That's a really good point. You'll have to bring that next time.
Excerpts 19 and 20, what we've done is number each use of the word. So this is one excerpt with two uses of the word.
You know why we stopped the show?
Tell me, please.
We stopped the show because a bunch of have a bunch of these organizations in the South End, and because all are choked out and killed 12 in 10 years. Really extraordinary, isn't it? 10.
Next we have excerpts 21 through 24, four uses of the word.
Hold on, Mr. Harris. Is that one of the enhanced versions?
That's what it is. To reduce the background noise.
Thank you. All right, 25.
Number 25.
That's on me.
That too is an enhanced.
So here's
tape.
what I did. Not always, but
Number
here's what I
26.
did. Some of them are inaudible. Like I can't hear what he's saying. So I don't know if there's a horrible word in there because I really just can't hear it. So what I do, instead of trying to bleep out anything, I just turn the volume down for a second. It was the only solution I had. There's no way you can hear anything in there. If you want to turn it up real loud and try to find one of those words where I didn't bleep out, you go for it. Knock yourself out.
Proceeding to 27, Your Honor, the record should reflect that this is the interview in which Lori Diaz is present, and these comments are also directed to her. And number 28 is likewise in the presence of Ms. Diaz.
How many people you killed there? Give me the opportunity. I haven't even know what it's giving me the opportunity. Yeah, you're talking shit. You're talking shit yourself. You're talking shit. You know, and until you've done something, you can't talk about it.
Number 29.
Big bunch of two guys, like 5, 6, they got frustrated days.
Number 30.
There's going to be a massive in the future, you know that. There's growing 60s. They want to just work this way. So 50 losing. 3,000 miles.
Number 31.
You could roll that back. I believe my name was listed incorrectly on that,
All right.
just as an addendum.
The tape,
This is number 31.
number 31.
Mr. Harris, would you run that back for us, please?
Yes.
At the beginning, the record should reflect the speaker is identified as McKinney incorrectly. Is that
That's correct.
Officer Furman speaking?
Yes, it is.
Thank you. Does that refresh your recollection?
Yes.
Do you recall these words being spoken by Officer Furman?
In the context of this, yes.
And in what context was that?
We were talking about a particular investigation, autopsy investigation of IA, Internal Affairs, related to an incident in the story.
And when and where did this conversation take place?
It took place in 1987.
Do you recall
approximately the summer of '87.
the date in 1987?
I don't recall the exact date. It would have probably been in the summer, or spring, or early summer.
Did you indicate a date on the transcript itself?
May I refer back to the transcript? I believe I
If
did.
that would refresh your recollection?
Oh, go ahead.
The date on the transcript is
No,
4.
just read it to see if that refreshes your recollection
Oh.
of when it was.
Does that,
I only recall that it was sometime in '87 in the spring or early summer. So yes, that refreshes
in
my
the spring or
recollection.
early summer of
Yes.
1987? And was that also in Los Angeles?
Yes.
And that would be true with respect to offers 34, 35, 36, and 37, Your Honor, that come from the same transcript. Do you actually recall word for word the words that Officer Furman spoke on that occasion?
No.
Is the transcript an accurate record of what Officer Furman said at that time?
The transcript would be an accurate record of what Officer Furman said.
And did you make that transcript soon after the conversation took place?
Yes.
How soon?
Within a day or two.
And you didn't change or in any way alter the words that you heard on the tape in preparing the transcript?
Sustain. Rephrase the question.
Did you put into the transcript the words that you actually heard Officer Furman speaking on the tape?
Yes, I transcribed the words I actually heard Officer Furman speak.
All right, thank you. Could we proceed to excerpt 34?
Station, and it's got the smell of that have beaten and killed him there for years.
They're big on objection.
That he's beaten and killed
Do you
over
recall
the
the
years.
context of that excerpt, Ms. McKinney?
It would be
Discussion
helpful
about the new
to see
building
it.
for 77th.
Do you
It would
recall
be
that?
helpful to see it. It would only be in discussing the 77th and perhaps after a ride-along that I had done.
Offer number 41, Your Honor, is not on the tape yet. It was added in our supplement to the defense amended offer of proof after it was located on a transcript of tape number 10. So if I could read it into the record.
It's actually at page 2 of your supplement, correct?
Yes. Quote, came up with a new name for anthrocide, A-N-T-H-R-O-C-I-D-E, dark gray color on Porsches. Now, nobody's going to mind being called a anthracide, do you think? Do you recall Officer Furman speaking those words?
Yes.
And do you recall when and where that comment was made?
No.
Is that a misspelling?
It was just done phonetically, Your Honor, so it may well be. If you could refer to the transcript of tape number 10 on page 16, please, of 41.
Yes.
Well, it's the most recent of all of the offers.
All right. What's the date on this?
1988.
All right.
Does that refresh your recollection?
I'm unable to find it.
It's not very coherently put together.
I think we may have the wrong transcript.
I'm looking at tape number 10, page 16.
I think we're looking at
I
transcript.
understand the problem. What you have there is the transcript of tape number 10. But what we want to refer to is your transcript, number 10.
Why don't you show it to her, Counsel? Do you have it in the book?
Of that transcript, page 16.
Thank you.
Just the half-page
Yes,
transcript.
I remember it from my transcript, not.
All right, I'm sorry, Counsel, which
Let me take that back.
page?
Page number 16 of the McKinney transcript, number 10.
Yeah, thank you.
Does that refresh your recollection?
Yes.
That appears under the name Farrell. Is that correct?
Yes, it does.
Does that have some association for you in terms of how this occurred? Or?
I believe there was an Officer Farrell with whom Officer
don't
Furman
know, but
had
I
worked
hope-
one time, and this is
I
a
hope he
portion of the tape
found
in which
himself
there were
in jail
categories
or something.
and then
Doubt it.
transcribed.
And
The transcriptions are Officer Furman's words, but the categories are regarding my questions or the areas of conversation.
and is the transcription an accurate record of words that were spoken by Officer Furman?
Yes.
And do you recall approximately when this conversation took place?
To my best recollection, I believe it was 1988. This particular example doesn't help me know that. There's something else on that tape that helps me know that it was 1988.
All right, so in looking at that transcript, there were other portions that reminded you of the time that the conversation took place?
Yes.
What was that?
There's one reference to being a good father, or on being a father, and at the time I was either pregnant with my second son, or had just given birth. So I remember that reference particularly sticking. And then I think there's another reference to 1988 being the year of the gangs, and the next year being something else. I don't recall it verbatim.
All right. So that, in context, was a conversation that you recall taking place in 1988.
Yes, I also remember this particular item because I didn't get it.
You didn't get it?
I didn't understand. It was a joke that I didn't.
Now,
Yeah.
This was a conversation that was taped over, is that correct? Where the tape was reused?
I don't know.
You haven't been able to locate the actual tape of this conversation.
That's correct.
But the transcript that you prepared, was that done shortly after the conversation took place?
Yes.
And is that an accurate record of what Officer Furman said?
Yes.
We can now move on, Your Honor, to the C category, the police misconduct excerpts. And the first 8 of these, the first 8 of these are all drawn from the first transcribed conversation. So if we could roll number 1 and then now, this excerpt indicates, in parenthetical, in response to a question, have you done that before? Nods. Do you recall these words being spoken by Officer Furman?
Yes.
And did you indicate in your transcription the reference to nods?
Yes.
And could you explain what you meant by that?
That Officer Furman nodded in the affirmative.
All right. So he was nodding his head up and down
Yes.
in an affirmative way,
Yes.
as though he were saying, yes, I have done that before.
Correct.
Thank you. Excerpt number 3. We could just stop that for a moment. Referring back to the list of questions that you gave to Detective Furman after this interview took place,
Yes.
do you still have that in front of you?
Yes.
If you could look at question number 16 of the follow-up questions you had posed for round 2 of your interviews.
Yes.
Question number 16 is, how do you hire someone who is capable of shooting someone in the back, number 1? And number 2, on what grounds would you determine who is capable of figuring out who the bad guys are? Refer to page 25 of the transcript. Were you referring, Detective Furman, specifically to this excerpt in posing that question?
Yes.
Thank you. If we could proceed to excerpt number 5.
Okay, time for me to get the next one ready. I have it ready. I just have to get to it. It's all good. Relax. So... Okay, found it. There we go.
From the arm of the suspect himself as planting evidence.
We're not at we're not at the right speed.
In that response, no, I wouldn't.
Sounds
If you
terrible.
edified me to regard those kinds of activities as planting evidence, then I would rethink.
Now, Mr. Darden asked you whether you made any independent checks of records to corroborate the information that Officer Furman was giving you. Did he ever offer to give you access to any police records?
Officer Furman?
Yes.
No.
At one point, he boasted of having 2,000 to 3,000 pages of investigations in internal affairs. Was it your understanding that you could just go down to internal affairs and ask to see those records?
No.
In fact, you knew enough about internal affairs to know that those records would not be available to you, didn't you?
Yes.
Answer standard was leading.
Now, with respect to the realism of the language that was used by Detective Furman, you were not asking him to assume a role other than himself in his conversations with you, were you?
Overruled.
On occasion, I may have asked him, what would this person say in a given instance, and he would tell me what someone might say in that situation.
Right, and those occasions would be indicated in the context of your conversation.
Sustained.
I mean, would those be situations where you were talking about a particular character and how you wanted to portray that character?
I was generally very specific about the situations and the character, whether it was something that the male officers would be saying in the locker room or something that would be happening at a particular situation where there would be only men, or something procedural, or something in a car. It was specific.
And those occasions occurred as you actually developed a finished screenplay. Is that correct?
It would be easier for me to ask those specific questions the more I knew about the story and the characters, yes.
Now, on at least one occasion, in the taped conversations, where we still have tapes, there was a conversation with Detective Furman about the nature of the language that was being used. Was there not?
Yes, there was.
All right. That was in the context of tape number 4. Would that have been the 4th conversation you had with Detective Furman?
It might have been the 4th taped interview.
All right. And let me ask if these words were spoken in the context of that interview. I'm referring to page 1 of tape number 4. You stated, "I just transcribe you." And Detective Furman responded verbatim. And you replied, "I have to." And he said, "All the cocksuckers, everything. That's important. That's policeman's talk." And you said, "It's life talk. It's not just policeman's talk." And he said, "But we have mastered it." No, the Marine Corps mastered it. Did that conversation take place?
Yes,
So he was aware of your need to have real-life language just as police officers normally talked.
yes,
And that's what you thought you were getting.
yes.
Later in that same interview, let me ask you if this was said. I'm quoting you, and this is on page 12. "Exactly. Look, Mark, all we're really trying to do, first of all, the premise is real clear. And none of the research that I do, no matter what I'm doing, riding
It's good.
along,
It's
spending
good.
the night in watch,
We like-
it doesn't change the premise. It's just that this kind of story is so controversial that it has to be so well documented that you get enough other people's point of view so that if somebody calls you on it, you say, 'Yeah, I did that. I heard what they had to say. I was there.'" And Officer Furman replied, "Yeah, the only thing is, are they telling the truth?" And you replied, "It's their truth." And he asked, "How do you prove it?" And you replied, "You perceive things the way you perceive them due to your frame of reference, background, and learned experience. Same with me, same with Joe." Did that conversation take place?
Which transcript are you referring to, Counsel?
Transcript number 4.
You're reading
Tape
it-
number 4, page 12.
What you just read is not on the transcript that I have.
It's in our offer of proof, Your Honor. Let me retrieve the transcript.
Well, I have here the transcript you provided me with tape 4, and that is not the passage that's there.
Stir it up.
All right, well, let's not waste time on this issue. Let's move along.
Do you recall that conversation taking place?
Yes,
But that concludes our redirect.
Any recross? Ms. McKinney, my understanding of the storyline then is that this was a woman officer who was going to be transferred into 77th Division and then partnered with somebody who's a member of Mao, correct?
That's correct.
Was there a subplot regarding racial conflict amongst police officers?
No.
You indicated that in discussing these matters with Mr. Furman, that you didn't confront him on any of the items that he might have mentioned to you that you personally found offensive, that you wanted to establish a level of comfort and I take it a level of candor in your discussions. Is that correct?
That's correct.
All right. Did you make any representations or agreements with Mr. Furman regarding any confidentiality concerning these tape recordings or any of these interviews?
My feeling was that the extent of confidentiality was implicit in our agreement, as were the agreements that I had with others who interviewed with Officer Furman.
All right. And what's the current status of the screenplay?
It is with my agent in Santa Monica.
All right. Is it still being, has anybody picked up the option?
It is not optioned as of now. No.
All right. Thank you. All right, counsel, any questions? I'll have the court's questions.
Your Honor, the reference that I was quoting is on page 12 of the tape transcription from lines 8 to 18. And it appears in the McKinney transcript, that is her transcript, at page 15.
All right, but what you were reading on the page 12 that I have was something different. It's about 80% the same, is my concern. So maybe you have a different transcript than what I have, what I've been working with here, which causes me some great concern.
Okay, I can tell you that what's in the offer of proof was prepared from the McKinney transcript. And we now have a separate transcription of the tape, which you have.
Okay. All right. You're just determined to make my life more difficult than it has to be, aren't you?
Not on purpose, Your Honor.
All right, anything else from Ms. McKinney?
Nothing.
All right, Ms. McKinney, thank you very much. You're excused.
Thank you.
All right, any other witnesses?
No, Your Honor.
All right, I'll hear argument. I'm sorry? Yes, I've just excused her. Yes.
Your Honor, in approaching the issues that these... Oh, I'm sorry.
Yep.
Wait.
All right, Ms. McKinney is withdrawn from the courtroom. It's a public hearing, counsel. Proceed.
At first blush, there may seem to be a remarkable similarity between the issues that we're litigating with respect to these tapes and the issues that were raised regarding the evidence of domestic violence, in which the court ruled on 59 different individual items of evidence. And,
My recollection, it was 74.
74. I'm reminded of Yogi Berra's famous aphorism that is deja vu all over again, and perhaps it's a comment on the duration of this case that we're having deja vu experiences in the course of litigating these issues. But I would suggest there is one very crucial difference between what we litigated then and what we are litigating now, and that makes all the difference in the world. In that context, the prosecution had only one argument, and that argument was based on Evidence Code Section 1101B with respect to the admissibility of prior similar acts. There was no question in the context of any of that evidence of the credibility of the defendant. And of course, Your Honor's ruling did not address the potential use that could be made of that evidence to cross-examine the defendant or as extrinsic evidence to impeach his testimony if he testified. So I think it's important at the outset that we recognize here the evidence has at least two purposes, and in many cases more than two. We are talking about double-barreled evidence, or in some cases triple-barreled evidence. It is offered not just to prove conduct, that is, to support the inference that Detective Furman would have altered or moved evidence in this case or presented perjured testimony in this case. More important, it is being used to challenge the credibility of a witness who has testified, to assist the jury in assessing his credibility and the weight that they should give to his testimony, all of his testimony, not just the evidence or testimony he presented with respect to the finding of the glove. And I think it's important to put ourselves in the position of the jury looking at the testimony of Mark Furman. I know that's hard. After we've read all of these transcripts and listened to all of these tapes and come to the sickening realization of who Mark Furman really is, Los Angeles' worst nightmare, probably the greatest liar since Ananias. But the jury has only seen a very polished and professional performance that was carefully orchestrated, in which Detective Furman sounded more like a choir boy. In one of the tapes he says, "I'm the only one who knows how to testify." Well, I think he certainly proved that in this courtroom. He flatly and unequivocally denied harboring any racial bias. He said he had not used the word in 10 years. And most important, he said that those who said any different were liars. All of them. And he was confronted with the statement of Kathleen Bell that in 1985 or 1986, precisely at the same time that these meetings with Ms. McKinney were going on, that he stated he would find a reason to arrest a mixed couple that he saw in an automobile, a black person with a white woman. He would stop them, and if he didn't have a reason, he would find a reason. And he went on to say that he believed that all African Americans should be put in a group and burned. And he denied making those statements, in effect labeling Kathleen Bell a liar. And he did it in a very convincing and persuasive manner. Now, items B1 through B41 of our offer of proof include 41 instances in which Detective Furman uttered the word all within the past 10 years, and there can be no doubt about that. There's no question, but that those words were not inserted into transcripts by Ms. McKinney unless they were said by Detective Furman, and of course we heard those words being used repeatedly on the tapes. All but 15 of the 41 instances are recorded on audio tape, and those that are not are in verbatim transcripts. Of these 41 references, 31
Do you
were
feel
in...
it's fair to characterize these transcripts as verbatim?
Yes, with respect to the words used by Detective Furman, absolutely, and
Well,
particularly...
verbatim transcripts in a legal context have a very specific meaning. I don't think you mean that.
Well,
You may be
obviously,
sub-
she was not transcribing them as a legal reporter to certify that every word that every word that was spoken was transcribed. And in fact, she admitted
listening to
that...
these tapes and comparing them with the McKinney transcripts indicate that there's substantial inaccuracy in those transcripts. So I don't think it's fair to refer. I don't think you should refer to them as verbatim transcripts because I think you overstate the case.
Well, I don't think substantial inaccuracies is a fair characterization either, Your Honor. The substance of what was said in every case is accurate. Where we have the tapes and can compare them.
Luckily, we have the tapes as to all but 15.
As to all but 15.
But that's sort of a warning that if you expect, I think the court, let's assume that I'm going to allow some of this. It'll only be with an accurate transcript.
And I think with respect to these uses of this word, we have an accurate transcript. We have the word being used in the context in which it was spoken, and we can with certainty conclude that the word was actually used, that Ms. McKinney would not inject this word if it had not been spoken and did not appear on the tape recording. I think it's also useful to sort out the temporal proximity and frequency of these words. That is that 31 of these references are in 1985, 4 are in 1986, 5 are in 1987, and 1 is in 1988. And to remember that the numbers are not a reflection of some sort of mellowing on the part of Detective Furman, but simply a reflection of the nature and the duration of Ms. McKinney's interviews. She conducted the most extensive, the longest interview process in 1985. The interviews that took place in 86 and 87 and 88 were of shorter duration, and that alone explains the frequency of the use of this word. And the use of the word, it's clear from the context, is not inadvertent, the kind of thing that one might forget. In fact, I think it's very important that Laura McKinney sent Officer Furman copies of the transcripts in which these words appear. So he had an opportunity to look at them. In fact, his attention was called to particular references in the first transcript, and that is the first one, number 1, where the tape is missing. He had a copy of that transcript, and he had a list of questions that referred to specific passages in that transcript.
Very similar to the civil process with depositions.
So he knew what was in there. Now, it's arguable, I think, and Ms. McKinney recognizes that and concedes that in only 2 of these instances, when the word was spoken, was it in the context of talking about a character in the screenplay, and those are B12 and B15. And the prosecution will argue, I'm sure, that where the word is spoken in this context, it should not be admitted in evidence. We believe that is a question for the jury, not a question for the admissibility of the reference, because the testimony that we are impeaching of Detective Furman was a flat denial of ever using the word without any qualifications. He didn't say, well, the only time I've used that word was speaking in a fictional context. So if we're going to put that kind of spin on the use of the word in any of these 41 instances, that's a question for the jury to decide as to whether that would be a context that would be within the scope of his flat denial of having ever used the word. So we believe that all 41 of these references, of these uses of the word, are directly relevant as impeachment evidence to directly contradict Detective Furman's testimony. But with respect to 17 of the examples, and that's the list that we provided to Your Honor this morning, we contend they are relevant for a second purpose as well. And that purpose is as evidence of Detective Furman's racial bias against African Americans. These 17 examples go beyond simply using an offensive epithet. They express overt hostility towards African Americans. They imply a judgment that people are of lesser value if they are black, that people can be treated differently because of their race. And that kind of racial bias and hostility goes directly to his credibility in terms of bias and prejudice. And we believe it's precisely the kind of bias and hostility that the court was speaking of in the case of In re Anthony P. And we cited the quotation from that case in our brief, in which the court makes the point that expressions of racial hostility don't necessarily mean that a witness would come in and give false testimony against a person simply because of their race. But by the same token, the court can't keep out those expressions of hostility by making the judgment, well, this witness's testimony is credible anyway, and I don't think the jury would discredit it based on these expressions of racial hostility. What the court in Anthony P. is saying is that these are questions of credibility for the jury to resolve. It's for the jury to determine whether these expressions of bias and hostility would infect the testimony of a witness so that they should mistrust that testimony, so that they should disbelieve that testimony. And that, of course, is a process quite apart from the direct impeachment of showing he used the word when he didn't. Here we're saying this is extrinsic evidence that he is biased, that he has hostility toward people of the African American race, and that hostility could and did, in this case, infect the credibility and believability of his testimony. Now, among these 17 examples, we contend there are 7 that are especially relevant for even a third purpose. Not only do they contradict Detective Furman's denial that he had used the word, not only do they prove his racial bias and hostility, but they give strong corroboration, independent corroboration, to the testimony of Kathleen Bell. Miss Bell's account of her meeting with Detective Furman in Westwood in 1985 or 86.
Redondo Beach.
Redondo Beach. I'm sorry, I stand corrected. That testimony was attacked even before she walked into this courtroom. The prosecutor, Ms. Clark, on the record, labeled this a fantasy cooked up by the defense. And Detective Furman on the witness stand flatly denied that it occurred. And indeed, without these tapes, it does sound a little bit implausible that on practically their first meeting, an LAPD officer speaking to a woman he barely knew would frankly admit that he would make up a reason to stop a mixed-race couple, and that African Americans should be all put in a group and burned. Well, that conversation was not in the context of developing a screenplay. And yet the credibility of Kathleen Bell's account can hardly be doubted after hearing the Furman tapes or reading the transcripts of what he said to both Ms. McKinney and to Ms. Diaz. And it's important that those statements are exactly contemporaneous. That is, they were made at precisely the same period of time that Kathleen Bell asserts she heard these remarks made by Detective Furman. These 7 statements are of a very similar tenor to what was said to Kathleen Bell.
All right, and for ease of referring back to these, which of these incidents are you
All right.
referring to as these second categories?
First of all, it would include item 4, item 12, and item 35, because these are 3 instances in which, very similar to the statement about finding a reason to stop a mixed-race couple, he indicates he would use race as the basis to stop someone. He refers to stopping someone in Westwood the night before because they were from 22nd and Western, and they didn't know where a particular restaurant was in Westwood. End of inquiry, into the car. Number 12, talking about whether you need probable cause to stop, to what he referred to as, he said, probable cause, you're God. And the Porsche incident, where he talks about seeing a black person driving a Porsche who wasn't wearing a $300 suit, you would immediately stop them. So it's the same kind of tenor as the statement made to Kathleen Bell at approximately the same time. In the second category, and this would include item 5, item 6, and item 40, he is actually talking in genocidal terms about...
All right, I asked you about the third category, in the third category.
Yes, that's what I'm saying. All of these 6 incidents, 4, 12, and 35 relating to arrests without probable cause, 5, 6, and 40 relating to genocide, which I think are very much the same tenor as a statement to Kathleen Bell about putting people in a group and burning them. In one, he says the black people on the city council in Los Angeles should be lined up and shot. In another, he refers to spending money to keep people in Ethiopia from starving to death as being a waste of money. And in item number 40, the reference to the building of a new precinct station, or new station in Division 77, that the old station should be preserved because it has the smell of who have been beaten and died within the premises of those walls. And there's one other we would put in this category, number 7, and that's 28. 28 because it is addressed directly to Lori Diaz, another woman he had just met for the first time, in which he says to her, you're talking shit, you sound like you're talking shit. The fact that he would speak that way to a woman he had just met for the first time speaks volumes about whether he would address comments of this tenor to Kathleen Bell in Redondo Beach at approximately the same time, 1985 or 1986. Now, moving on to the second category of our offer of proof, which is subdivision C, items C 1 through 18. It's important, again, to remember that this evidence also has 2 purposes. It is not just to prove conduct under Section 1101B, but also to attack credibility. Now, the prosecution argument in their brief is that many of these excerpts are statements of attitude, so they don't really qualify as acts that would be admissible under 1101B. We believe, first of all, that's an inaccurate characterization, that in most of these incidents, Detective Furman is describing conduct. In most cases, his own conduct. In other cases, the conduct of other officers that he observed and approved of. But even attitude, I mean, even to the extent these merely show his own attitude, it is highly relevant to challenge his credibility.
I wouldn't go that far.
Because Section 780J of the California Penal or Evidence Code, in laying out the grounds upon which credibility may be challenged, includes, as subsection J, the witness's attitude toward the action in which he testifies or toward the giving of testimony. And I think it's important that 1101B underlines the point by saying in 1101C, nothing in this section affects the admissibility of evidence offered to support or attack the credibility of a witness. So we're talking about 2 completely independent grounds for the admission of evidence. 1101B, when we're offering conduct to prove similar conduct on a later occasion, and 780J, when we're talking about the attitude reflected in these descriptions by Officer Furman and how that relates to his attitude toward the giving of testimony in this case. These incidents, every one of them, provide fertile ground for further cross-examination of Detective Furman about his attitude toward the giving of false testimony and the planting or manufacturing of evidence. Whether we call it an attitude, a philosophy, an MO, or just call it unmitigated gall, we now have a good faith basis contained within these tapes and transcripts to put Detective Furman back up on that witness stand and ask him, Detective Furman, have you ever destroyed evidence? No. Well, what about the driver's licenses you were talking about in these tapes and transcripts? Have you ever criticized LAPD officers because they wouldn't lie? No. What about your partner, who you said had more morals than he had hair on his head because he wouldn't lie? Have you ever manufactured evidence? No. What about the occasions when you scraped the scab from an addict so that you would have fresh blood to justify an arrest for being under the influence of a drug? And I think that's particularly relevant in the context of a case where we're talking about blood evidence. Do you believe, Detective Furman, that police should play by the rules? Yes? Well, what did you mean in these tapes and transcripts when you said, fuck the rules, we'll make up the rules later? Detective Furman, did you ever testify to events you did not observe? No? What about that incident you described when you were the fourth car on the scene and you came in and testified because, quote, you were the only one who knew how to testify? I'd go on and on. Do you believe you have some special ability to sort out good people from bad people on the basis of where they live or the color of their skin? We have the switch hitter description. Do you believe police officers should never testify against each other? How else do you explain the references in excerpt C9 to the group being tight and getting away with something that you knew they had done because the group all told the same story without even having to consult with each other?
Well, speaking of C9, would you address the argument that the prosecution raises regarding factual bases for some of these?
Yes, Your Honor. To the extent that they are going to argue that these incidents should not be admitted because Detective Furman has a tendency to exaggerate, to puff, to put in details that did not happen. That may be a fertile area of inquiry with Detective Furman, but we believe in the record we already have, there's ample corroboration of the basic facts that he's describing. In fact, one particularly telling example of that kind of corroboration can be found in the very psychiatric reports that were prepared when Detective Furman applied for a disability. And these are the terms in which he described this same incident in 1982 when he is going to the police department and saying, I want to be relieved on the basis of a disability. He said, I had 2 friends shot by a bunch of those slimes.
I don't see why.
He rose a beef
This is
for
all
18
fun.
months regarding what happened to 4 guys that he and his partner caught. He says he was smarter than the people who investigated this incident. He says, quote, you don't see, you don't remember, and it didn't happen. Those are the 3 things you say, and you stick to it. So that's his account of this incident in 1982, 3 years before these tapes were ever made. So there's plenty of corroboration. I believe we can show that in the essential details with respect to covering up, there is corroboration.
How are we going to do that?
Well, first of all, we can do it with the inquiry of Detective Furman on cross-examination.
Given the very rapid-fire cross-examination that you suggested, and which, if it happens, I would like for you to do it, since you seem to be able to do it in a very quick manner, Mr. Ullman, do you think counsel representing Mr. Furman would allow him to testify in light of that proposed line of questioning?
That is a bridge we will cross when we get to it. We intend to call Detective Furman to the stand. We believe, I know that he was not excused. He is subject to further cross-examination. If he does invoke the Fifth Amendment, that simply means he is now no longer available as a witness. Once he's no longer available as a witness, every one of these items becomes admissible as a declaration against interest under the evidence code, and we believe we can offer it extrinsically to impeach his testimony. We can offer it to show the pattern of conduct under 1101B. We can offer it to show habit under 1105. And if they want to come in with some counter evidence saying, well, this stuff isn't
Plus, I'm pretty sure you're not allowed within 400 feet.
all true, Detective Furman was lying or exaggerating, they're welcome to do that. In fact, I'm looking forward to hearing that argument addressed to the jury, for the prosecution to get up and say, ladies and gentlemen, all of this stuff you heard on the tapes of Detective Furman admitting that he lied, that he planted evidence, that he tore up driver's licenses, you shouldn't trust that, because Detective Furman exaggerates. So just ignore that and believe his testimony on the witness stand, as though his tendency to exaggerate had nothing to do with the testimony he presented when he got on the witness stand and testified in this case. That's an argument I look forward to hearing, because I think we'll have an answer for it. So it's not a question of, we can't let any of this in unless we have independent evidence showing that it actually happened. We have here the statement of the witness himself, in which he is recounting it. And to the extent that the prosecution wants to undercut it, to challenge it, to say it's an exaggeration, to show that some detail is not accurate, they're welcome to bring that evidence in and present it and argue it to the jury. Now, apart from the attitude,
But just, shouldn't I be concerned, though, that then I have to try 18 little trials? Shouldn't I be concerned with that?
no, I don't think Your Honor should be. Number one, it's very unlikely that we're going to see that kind of evidence brought in with respect to all 18 of these incidents. I think for the most part, the description that we have culled through the editing process from these transcripts is a very precise description. It's not going to occupy a lot of detours or false pursuits in terms of litigating the accuracy of every one of these incidents. What's relevant is not just whether they happen, but the attitude they reflect on the part of the witness. The fact that he is personally boasting about engaging in this kind of activity says a lot about the credibility we should give to the testimony he presented from the witness stand about what happened in this case. And bear in mind, Your Honor, that Detective Furman was on the witness stand, I believe, 6 days. Was it a total of 6 days? It was close to that. It was a major part of the prosecution's case. It's the foundation for the most significant evidence that they presented against the defendant in this case. So to be concerned that with one or two of these incidents, we may have some evidence that they want to bring in challenging the accuracy, let them make a proffer of what challenges they have. And I hope it's a proffer that's better than the one they offered in their brief, which was simply a citation of the Los Angeles Times. If they have some evidence to challenge the accuracy of any of these incidents, let them offer it, and then Your Honor can make an assessment of whether indeed that will take us off on a tangent that would consume too much time. Now, let me quickly address the 1101B issue, because here again we are on that familiar terrain that we trod in the context of the earlier motions litigated in this case. Apart from the attitudes on the part of Detective Furman reflected in each of these 18 police misconduct excerpts, they are relevant to prove motive, opportunity, intent, preparation, plan, knowledge, identity, and absence of mistake or accident. And we believe that any evidence allegedly collected or observed by Detective Furman should not be trusted in this case because on prior occasions he has destroyed evidence, ripping up driver's license. He has planted evidence, including fresh blood from the scab of a hike. He has testified falsely, making up probable cause. testifying to events he did not observe. He has beat suspects in order to obtain confessions. He has ignored department rules and regulations. He has covered up the misconduct of other officers. These are all specific instances of conduct that are relevant to show his intent, his motive, his opportunity, the lack of mistake or accident, all of the items listed under 1101B that permit the...
Oh my Lord, shut up. We get it. You made your point 17 trillion times in this stream so far. Move on. What you showed was crystal clear. Shut up. Stop talking. I know that's what people say to me a lot, but I've never... Okay, maybe I have done that. I'm not going to lie to you. But my Lord, he just keeps going. We are... Hold on. Let's just see how much longer he goes. Okay. All right. He took me to my breaking point, but he's almost done. We got this.
The admission of this kind of evidence. There are 6 incidents that we believe are relevant for a third purpose, not only to show attitude, not only to show 1101B conduct being repeated, but for the third purpose of showing habit or custom under Section 1105. And there's an important difference between 1105, Your Honor, and 1101B, because 1101B does talk about the admission of evidence that a person committed a crime, civil wrong, or other act. But 1105 says any otherwise admissible evidence of habit or custom is admissible to prove conduct on a specified occasion. And that means it doesn't have to be evidence of an act. It can be evidence of an admission. It can be evidence of a practice. Or it can be evidence of a specific incident or act. And we believe that the most chilling of the incidents of police misconduct that we have culled for purposes of the offer of proof are when Detective Furman talks about how it really works and how it has worked in the past. Especially item C9, where he talks about how I got away with it. I got away with it. They knew I did it, but I got away with it because we were tight, because 37 officers from that division told the same story without having to call each other up and consult each other. What he's describing is what we will contend is the code of silence. And he identifies it in even more chilling terms in item C10, when he talks about his disgust with a partner who won't lie for him. If he's not describing in that excerpt a code of silence, I don't think we could find a better description of the code of silence, of the understanding that police officers cover for each other. And the reason this is particularly relevant in this case is because the prosecution's argument with respect to the planting or moving of evidence by Detective Furman is it couldn't have happened because there were other police officers around. So they're going to argue to the jury to reject any suggestion that there could have been any tampering with evidence by Detective Furman simply because there were other cops around. Well, when this same cop gets on tape and describes how police officers cover for each other and lie for each other, we believe that's relevant in terms of how the jury is going to assess this explanation. It couldn't have happened because there were other officers around. There are also references to covering for each other in item C6, where he talks about being able to kill someone if you have a partner like a brother. Item C14, item C1, and item C13, both of which he specifically refers to how he describes what he did or how he conducts himself depending on whether there are witnesses present or not, and applies 2 different standards if there are non-police third-party witnesses present observing what he is doing and how that affects how he describes what he is doing. So we believe these 6 items, C9, C10, C6, C14, C1, and C13, are all highly relevant
See
under
my
1105
headache you gave me.
as evidence of
You
habit
gave me a
and custom.
headache, sir.
The final category in our offer of proof goes directly toward Detective Furman's attitudes towards his testimony in this case, attitudes that we inquired into on cross-examination, asking him whether he realized the importance of the glove.
Thanks for taking, a good part for the jury and then just completely, oh, no, wait, jury's not in right now. Jury's not in. They're just talking about, to the judge, are they allowed to play any of these clips? Not, they didn't play them for the jury. They're going to. I mean, okay, spoiler, they're going to play them for the jury. Longer than those little snippets we got, too.
Of to this case, what kind of preparation he went through in order to prepare him to testify in this case. And here, virtually contemporaneous, just before the beginning of the trial in this case, we have him in taped statements directly addressing his role in this case, describing himself as the most important witness in the case of the century, and that if he goes down, the case goes down. Describing himself as Bloody Glove Furman, and suggesting that if he's going through all of this agony, he should make it pay, that there should be some payoff for him from what he is experiencing as a witness in this case. Finally, Your Honor, I want to address the 352 arguments. And I believe that these are arguments the Court has already addressed. When Your Honor directed the parameter of the cross-examination that would be permitted of Detective Furman in the first place. And at that time, Your Honor heard the arguments about how a jury might react to this evidence and ruled by limiting the cross-examination of Detective Furman, but recognizing that this was not an issue that could be avoided, and that we can trust, indeed we must trust the jury to treat this evidence appropriately and not overreact because of the inflammatory nature of the evidence. We believe we've been very sensitive to that. We took 13 hours of very, and Your Honor listened to all of them, very inflammatory tapes, something in there really to insult everyone. And we very judiciously edited it to a bare minimum, to a tape that the tape itself takes less than an hour to play. So we're not trying to capitalize on this. The 352 arguments about how the jury might react to this evidence are an especially strong deja vu experience for me, because they're the same arguments I made on the other side when we were arguing that Your Honor should keep out the evidence of spousal abuse, that Your Honor should keep out the gruesome autopsy photographs. And we were arguing, well, there's a risk that this evidence will be used for the wrong purpose, that it will be used as evidence of bad character to show a propensity on the part of Mr. Simpson. And Your Honor, it's important, I think, that risk, where that risk exists, is much greater where the evidence is offered against the defendant who's on trial. And the risk of prejudice is that this evidence may be wrongly used against him, then the risk that's presented when we're talking about a mere witness who is testifying on the witness stand. And the risk in terms of personal risks to him are simply not of the same dimension as the risks for the defendant who is actually on trial. At that time, Your Honor expressed confidence that the jury is capable of following the instructions, of using the evidence for the limited purpose for which it is admitted, and we believe there is no reason not to have the same confidence in the jury with respect to this evidence. Your Honor concluded, for example, in the context of the gruesome autopsy photographs.
Mr. Ullman, I have to tell you that one of the most unconvincing lines of argument as a judge is comparison with prior rulings and mixing apples and oranges. I think the closer comparison of your 352 argument is this Court's ruling January 20 regarding Kathleen Bell and the confidence that I had in the jury that if we had to use the racial epithets, if they came in an appropriate context. I mean, those are the rulings that are similar in the same context. Autopsy photographs are interesting, not relevant to this argument.
All right, I won't press the point.
And not helpful to me.
The only analogy I was seeking was that we don't reject evidence because it is painful to look at. And Your Honor noted that. Murder is ugly. Jurors have to face it. They have to confront it.
Racism is ugly.
Racism is ugly. These tapes are ugly. These transcripts are ugly. Furman is ugly. And I would hope that if any good comes out of the painful process of this trial, it is that we confront that ugliness, that we look it in the face and we deal with it. And we think the jury is capable of doing that.
Madam Reporter, how are you? Small? All right. Okay, we'll take a quarter recess. We'll take 15. All right, back on the record in the Simpson matter. All parties are again present. I'll hear from the people.
Thank you, Your Honor. Let me begin by saying that the content of these tapes is so repugnant and so offensive that this may well be the most difficult thing I've ever had to do as a prosecutor. I don't think that there is anyone in this courtroom, in this county, that could possibly envy me. And I'm talking about any prosecutor or perhaps any defense attorney. And as a citizen, I am deeply offended, and I'm shocked, and I'm disgusted with what I've heard. But I cannot afford the luxury of being Marcia Clark the citizen. I am Marcia Clark the prosecutor, and I stand before you today, Your Honor, not in defense of Mark Furman, but in defense of a case of such overwhelming magnitude in terms of the strength of the proof of the defendant's guilt, that it would be a travesty to allow such a case to be derailed with a very serious and important but very inflammatory social issue. And what has occurred, and what the defense is attempting to do, is to tell the jury to turn a blind eye to the evidence, a deaf ear to the testimony, disregard logic, dismiss reason, and listen only to racial epithets and bragging accounts of hideous acts of misconduct, if any are true. And I pray that they are not. The point, Your Honor, as I was trying to make to the court earlier, was not to suppress the information. The information should be let out. The information should be publicly aired. It should be investigated. It should be examined carefully. Every single alleged incident to determine whether or not it did happen or did not happen. And Mr. Hahn, the City Attorney's Office, is present to accomplish that very goal. The point I make is that this is a murder trial where none of this is relevant. This is not the forum. This is not the forum. We need to keep our eyes focused on the evidence that is relevant to this case. And it's funny, I wanted to share with Your Honor something I saw, that occasionally these cartoonists come up with something that's edifying. It's a little child speaking to his mother watching television who says, what's the forbidden N-word they keep talking about, Mommy? She said, Nicole. I think that sums it up. I think that's what it's all about. And I think that we have to look carefully to the law in a lawyerly fashion and see if there's anything here that is legally relevant, that belongs in this trial, that this jury should hear about. The defense asks the court to take the escape hatch, if you will, Your Honor, of saying, let the jury decide. That's that great way of avoiding all responsibility and saying they can figure it out. Obviously they can't. That's why we have rules of evidence. There comes a point after which you have to say, a jury's just never going to be able to winnow the wheat from the chaff, to get past this, whatever the this may be. And we've seen evidence of it in the past, and that's why the courts have ruled that there are certain things that just are so inflammatory or irrelevant or confusing or time-consuming that they do not come in, or unreliable or untrustworthy. That's really the bottom line of the evidence code. It just should not come in for much of those reasons. This is a case like that, and you saw in our brief references throughout history to various socially inflammatory issues of the day in which the court said, no, you don't get to bring that in, because all you will do is inflame the jury unfairly and cause them to look away from the evidence or read too much into it. And that is the problem we face with this evidence. Now, I find it very interesting that the defense, in its argument, never once really alluded to the evidence in this case. And it does highlight the very point that I'm trying to make, Your Honor, is that you cannot get away from the factual predicate if you are to base an intelligent ruling on what should come in on this case. You have to look at the facts that we have. And what are those facts? It is a fact that we have a number of police officers already at Bundy before Detective Furman ever got there. It is a fact that those officers saw one glove at Bundy before Detective Furman ever got there. It is a fact that Detective Furman was never alone outside around the evidence where he could have gotten a glove to take to Rockingham. And it is a fact that we have thumps against Cato's wall right where the glove appears. And if the defense theory is to be accepted, the thumps on the wall, which no one disputes occurred, that's an accepted fact, the thumps on the wall would have to have no connection to the appearance of the glove. That's ridiculous. Suspension of reason, suspension of logic. We also have to believe that Detective Furman is going to go and move evidence in a case where he doesn't know if there are eyewitnesses, he doesn't know if there are ear witnesses, he doesn't know if Mr. Simpson has an alibi, he doesn't know what the other officers have seen or done, among many other things. I can just go on and on with that. Ridiculous comes to mind.
Carpet fibers on the glove.
Right. Bronco fibers on the glove, on the Rockingham glove, and on the knit cap. I mean, these are things that Detective Furman could not know. You know, this is way beyond the ken of anyone. And then, you know, so to say that he's going to plant evidence when he doesn't know what it's going to turn up, let alone what the blood typing will turn up, and that will get me into yet another of the defense arguments, which is beyond silly, is you have blood evidence that comes back on the Rockingham glove to the defendant, Ron Goldman, and Nicole. Now, how can you plant the glove? What if the third party that comes up on that glove, in that blood, is someone other than the defendant? Then, hasn't Detective Furman completely messed up a murder scene? He has dumped a glove where it doesn't belong. It'll mean nothing when the blood evidence is finally analyzed, except point the finger at him. And by the way, Your Honor, while we're at it, if there's going to be evidence planted, why not plant a fingerprint? It's so simple. We don't have to worry about autorads and laboratory error rates and Dr. Weir and population genetics. Plant a fingerprint. So simple. No one thought to do that. If there was going to be evidence planted, I would think they would do a better job. But that's what's so silly about this. Now, the defense counters with the tortured logic that, of course, the conspiracy had to involve more. And this is what you heard Mr. Ullman argue. This is another glaring problem with the argument. They would seek to bring in Mark Furman's statements to swipe the entire police department, at least every police officer out there at Bundy.
Swipe has a particular connotation.
As opposed to compression, that's right.
Yes.
I mean, to basically just to color the entire police department with the same brush that they do Mark Furman. Mark Furman makes certain statements. That may or may not truly be his state of mind. It may be posturing for Laura McKinney. I don't know. But the unfairest cut of all is to allow them to bring in such evidence in order to impute that state of mind to other police officers. Lieutenant Spangler thinks that way. Detective Ron Phillips thinks that way. Detectives Van Adder and Lang, on the eve of their retirement, due to collect their pension, are going to risk it all for this D2 they met that night? I mean, what, are they kidding? When I think about it in those terms and I think about the jury, I think, they're not that dumb. But the problem you have is not an issue of intelligence. It's an issue of emotionalism. It's an issue that is so inflammatory, I get upset when I think about it. I get upset on levels that go way beyond the case, way beyond it. Levels that take me back to when I was a teenager and believed that we were going to eradicate all this. We weren't going to have to be talking about this anymore. And here we are. I get totally unfocused. I get totally taken away from this case and onto my disillusionment, my discouragement, my frustration, my anger that this insanity still exists. And this is what we invite to the jury. I'm a professional. I'm supposed to be able to not do that. And I have a hard time, very hard time. Now, the factual predicate that I urge to the court, I urge for a very specific reason. Counsel brought up the case of Anthony P. And in their moving papers, they also cited Mascarenas. Now, it's interesting they cited Mascarenas, Your Honor, because I was going to cite that in our moving papers, because I think that it's a case more helpful to the prosecution. And the reason for that is this. Mascarenas makes it very clear.
You don't get to. They already used it. They called dibs. You don't get to just use it now because you want to. Move on. Spoiler alert. She's just not going to move on. She's going to keep going. Whatever.
That it is important for the court to determine when it weighs impeachment evidence to be offered, the nature of the inculpatory evidence offered. In Mascarenas, the court took great pains to point out the fact that the prosecution case, as I recall it, the statement, was far from overwhelming. And in that case, it was a case of one-on-one credibility where a minor who was aspiring to become a narcotics officer was working undercover for a police officer. And he claimed that the defendant sold him codeine. And he turned the codeine over to the officer. And only his uncorroborated testimony, that was the sole testimony and evidence offered to prove the defendant's guilt. the court noted the fact that the defense proffered evidence of very probative value to show that this minor had worked for this undercover police officer on 2 prior occasions, and on both prior occasions were able to show that either, 1, the minor fabricated false charges and proffered them to the officer to get a filing, or 2, that he actually, I believe it was, stole liquor in order to curry favor to get a customer to sell him drugs so that he could make a case, again, for the same officer. But the conduct and the logical nexus is shown there. Now, this is a one-on-one case, not ours. Our cases, if we took that Rockingham glove and threw it out, we'd have overwhelming proof of the defendant's guilt. I mean, that's how strong this case is. That's how little this case relies on Detective Furman. And I smile when Mr. Yeoman argues the point about Mr. Furman being such a critical witness. He knows better than that. Mr. Furman's not necessary to our testimony at all, because we have Detective Lang, Detective Van Adder, Detective Phillips, who all saw the glove in place. Detective Furman didn't even collect it. He saw it, he went and brought everybody back there, they all saw it, and then Dennis Fung collected it. We don't need Detective Furman. And he knows that. Detective Furman's view of whether he's an important witness or not has a great deal to do with the fact that he's trying to sell his role as a technical advisor in this screenplay to Mr. Flynn in the relevant passages. And by the way, I should mention to the court that the defense neatly steps around the excerpts where he vehemently denies planting any evidence in this case, where he vehemently asserts he was doing nothing more than his job in this case. He said, you know, I've had many more interesting, exciting cases where I had so much more involvement and really did some work.
He's gonna say
I
that.
was just out there just doing my job. I happened to see this glove, end of line. And I get all this. But then, if only because of the defense tactics, Mark Furman likely thought he became very important. That was his view, and it may very well have to do with the fact that they've decided to make him a key aspect of their case. Nevertheless, he's not important to ours. So we have a case that is so solid in its corroboration. All of the physical evidence, the DNA evidence on the Rockingham glove, on the defendant's sock. We have, and at the Bundy walk, we also have the hair and trace evidence of very powerful magnitude, showing the Bronco fiber on the hat, on the Rockingham glove. We have the blue-black fibers connecting the defendant's sock to Ron Goldman's shirt and to the Rockingham glove. We also have the defendant's hairs on Ron Goldman's shirt and in the ski cap. I mean, this is an extremely powerful case that requires no one witness for its proof, but many. Mark Furman, the least of which. Now, contrast that with Mascarenas, where you have one defendant, one alleging accuser as the witness, with no physical corroboration whatsoever. And the court appropriately looked at that and said, here it is. Eric's testimony, and that was the minor, is the only evidence in any way tending to establish appellant's guilt. That testimony is totally uncorroborated, there apparently having been no effort made to supply Eric with marked funds for a transaction or to conduct a surveillance of his meetings with appellant. The prosecution's case was by no means overwhelming. There was not a scintilla of corroboration for Eric's testimony. That makes it clear that the focal point was the lack of corroboration and the fact that you have one-on-one case. Anthony P. is the very same thing. In Anthony P., you had the allegation made of sexual harassment by this girl against a guy in her class. I think they were both minors. I think they were both in high school. And it happened that he was African American and she was white. And the defense, it was a one-on-one case. There was no other corroborating witness, no physical evidence. And the defense sought to attack her racial bias as a basis for fabricating the charges, which, in that context, she could have done. It was physically capable for her to do it. And in showing bias and a motive to do so, there was an opportunity for her to do so that made sense that they should have been allowed to. In this case, contrast with this case. The defense in the beginning of this case has made many, did a lot of posturing about how they would show that the glove was planted at Rockingham. Not only have they failed to do that, but their posturing has been exposed as baseless, as a sham. They can't. All of the evidence has proven conclusively and consistently that there was nothing planted in this case, that Mark Furman had no opportunity to do so, whatever his attitudes, whatever his beliefs, whatever he would have liked to have done. He could not do it. And the evidence has now demonstrated to this court that even under the third-party culpability analysis, Peeble versus Hall, that where they say mere motive and opportunity is not enough to bring in evidence of a third party, in this case, we don't even have the opportunity. Assume you have the motive. So they don't even come close in this case. They have failed in their proof. If they wanted to get in this kind of evidence, the kind of proof they should have brought to this court, the kind of evidence that they should have been able to proffer is, I was at Bundy, I saw 2 gloves. Or I was at Rockingham, I saw Mark Furman run behind there and drop something. It never happened. No such thing ever happened. And in fact, what we have here, I mean, what's really kind of interesting is, for all intents and purposes, given the state of the evidence, Your Honor, and what the officers testified to at Bundy, Mark Furman may as well not have been there. I mean, when you look at it in an analytical sense, what they're looking to do is bring in a whole bunch of inflammatory material on a witness who had a very small part in this case, whose part they want to pump up as big as they can so they can make this issue as big as they can, to totally divest the jury from this case. And the admission of this evidence is, in essence, telling the jury, disregard the case, look somewhere else. I know that, I do want to remind the court of the January 20th ruling.
Marcia,
January 20th, I think.
that's what they're supposed to do. Also, Marcia, they're not exactly lying. Your side actually lied. They aren't exactly lying. They're just playing tapes that he actually said. So I don't know if I'm with you on this one.
Where the court ruled in its written ruling concerning the admissibility of Kathleen Bell. And the court at that time said that it found it to be relevant because there was a juxtaposition of two things. And that is the indication of racial animus, that is the willingness to focus on an interracial couple, juxtaposed with fabrication of probable cause, that he would make something up in order to stop them. And it was the combination of those two factors together that made the court determine it to be relevant. Now, in this context, that now that we have seen that Detective Furman could not have planted any evidence, I would think that the standard would get even higher, but certainly it would not get any lower than that. In none of the excerpts that the defense has proffered have we seen any evidence that Detective Furman would fabricate or move evidence in order to frame someone because they are African American. And I wanted to read to the court in context the passages that Mr. Ullman has stated he feels are relevant for that purpose, because I think when you see them in context, let me see, proffer 4. Now, proffer number 4, of course, the court is aware that's, again, the transcript without a tape, and I will address, well, I'll address it now. We have a real problem with these transcripts without the tapes, Your Honor. The court has already noted the substantial variance. I had pulled out a few of the examples, but since the court is aware of it, and the hour's getting late, I think it's probably unnecessary. But if the court would like me to...
It's a 6 o'clock day.
That's true, but you've been listening to us talk for an awfully long time.
That's what I'm paid to do.
That's true. Would you like me to cite them for you?
It's your record, counsel.
Okay.
But I have read the transcripts. I have listened to the tapes.
Right, then perhaps if I can just refer to it in the record so that the citation is in the record,
All right.
and I won't have to waste the court's time. I won't read it.
Actually, Ms. Clark and Ms. Roman will go to 5:30 today.
Okay. I'll be done waiting for you then. I'll have that in a minute, Your Honor, just so I can put that cite in the record. But we do have a real problem with the accuracy. In a case where we are leaning on every word and every nuance and the context in which it's made to make arguments to a jury, it's extremely important that we have a very accurate transcript, one that gives the entire context in the most accurate manner possible. Obviously, we don't have that in this case. And as we were going through one of the, I think it was proffer number 12, it became very clear that the transcript prepared by Ms. McKinney and the transcript prepared by the defense were at variance. Even as to one small excerpt. So we have real substantial problems with that, and with the inability for the people to ever accurately determine whether there was some license taken by Ms. McKinney, whether there were things left out that would have minimized or aggravated the passage. We'll never know, because she cannot remember what is not in the transcript, and that much is very clear. So with that caveat, proffer number 4 goes to transcript number 1 at page 33. Mr. Yeoman cites this as an example of how Kathleen Bell is corroborated. Here's the entire passage. Like last night, I picked up this burglar. He's a known burglar and car thief. And he lived at 22nd and Western, and he's up in Westwood, in the residential area. I just threw him in the car, handcuffed him, took him to the station. How did you know he was a known car thief? He was a African-American. He didn't belong. 2 questions. And you're going, where do you live? 22nd and Western. Where are you going? Well, I'm going to Fatburger. Where's Fatburger? He didn't know where Fatburger was. Get in the car. So under what did you arrest him? I didn't arrest him under anything. Just took him to the station, ran him for prints. Gave them to the detectives to compare with what they've got in the area. I'll probably arrest a criminal that way. Now, when you put all that in context, how is that a fabrication? What has he misstated there? He is stating to her, I have seen these things, I have heard these things, and my experience tells me something's wrong. We know that police officers act on these hunches all the time. Sometimes they're right, sometimes they're wrong, sometimes what they do amounts to an arrest without probable cause, in which case the case is thrown out, sometimes it doesn't. But how does that corroborate Kathleen Bell? How does that show that he is singling this person out because of his race? What he is saying, in fact, is that he's looking at the way someone is behaving, at their inability to answer certain questions. He used a racial epithet in that context.
I agree,
but it
Carlos.
certainly is a far cry from what Kathleen Bell said. It's a far cry from that. Proffer number 12. So it's clear, Your Honor. I mean, I'm reading that passage to you. In no way should it be understood that I think, or have ever thought, that anyone's race or gender should be something to be considered as to whether or not someone gets arrested. But I think that what I'm actually saying is I'm distinguishing this passage from Kathleen Bell, because that was one of the theories on which it's been offered today by Mr. Ullman as corroborative, and I don't see it as corroborative. And proffer number 12, again, now the problem with proffer number 12 is that this is clear acting. In this one, she is asking him, how would this officer react if this situation occurred? And then he's playing it out for her, and it's fictional. I mean, it is fictional. It's admittedly fictional. There's no bones about it here. And that's in tape number 1 at page 26. And the lead-in is, they're talking about, McKinney says on page 25, missed a gun? No, this is not the one that's missing the gun. Oh, okay, I got you. This is the one that's the really competent one. Oh, okay. McKinney says, plays the female lead. Furman, you're in the 77th Division. I think the scene here, you leave them in. You make it summertime. Okay. It's not getting dark until about 8. You get the flavor. That's the whole passage, is we're talking about a scene. They're setting a scene. So we're not even talking about a fact here. Proffer number 35. In this context, we have the use, again, of a transcript without a tape. So we have the same problem we confronted with the other one. And this is the problem again. In the proffer, they say this passage occurs on page 11. Oh, excuse me, Your Honor. This is the one that's on tape. Okay. Let me read the beginning of this passage so that the court can get the flavor, because again, the context is Mr. Ullman is saying this indicates a willingness to fabricate evidence or to plant evidence. Guy doesn't know how to drive it very well, like a stick shift, especially a Porsche. Big lulls where the car drops a little bit between shifts and jerks a little bit. So it starts out, and then it goes into some of the other stuff, and then continues. Somebody doesn't seem to know how a car drives too well. License plate's dirty and the car's clean. So, and then it goes into, we work the same 10 blocks, square 10 blocks every day, etc. There's a lot more there, but what's indicated, and I refuse to repeat the racial epithets, but what it indicates is not a willingness to fabricate evidence. It does not indicate a willingness to move evidence. He's talking about what he sees. He's not talking about a willingness to take a piece of evidence and incriminate someone because of their race. That's the issue that we have here. That's what the defense is trying to prove. And, of course, it's not appropriate as propensity evidence, but the point is, Your Honor, that even if it were, the passages cited by counsel do not prove that. That's the problem that we have. We have a capital case here. And the commission of perjury in a capital case that causes someone to get the death penalty, which Mark Furman could not have known whether or not that would happen at the time he was out there at Bundy. If you perjure yourself in a death penalty case causing someone to receive a sentence of death, you yourself are sentenced to death. He's willing to do that? There is nothing in here. There is nothing in these tapes, nothing in these transcripts that even comes close to what the defense is alleging in this case, let alone the conspiracy that they're trying to allege here with the code of silence. Now, and that brings me to another point, which is, if the defense would to be allowed to bring in this code of silence argument,
I missed something.
which
She said she's going on to another point. Did she land a point yet? Did she actually land a point yet? I didn't hear one being landed. I hear her saying a lot of words. Reaching, grasping.
Would be vastly inappropriate, wildly inappropriate. Then, in response, would the people be allowed to bring in all of the good officers who've done acts of heroism, acts of courage, saved lives, to show the jury that that conspiracy stuff, has a lot to do with comic books and nothing to do with the evidence in this case, and there are good police officers out there, too. I mean, you want to talk about a mini-trial? We'll be here till 97 proving all this stuff. There has to come an end to this at some point, but we do have to use the rules of logic and the rules of evidence. And that's what the defense is trying to prevent. The very cross-examination previewed for this court by Mr. Yeoman shows you the way the admission of these tapes will derail this trial, and all without any basis in the evidence. When you look at the passages that I've now shown to the court in context, you can see that the conduct they're talking about bears no relationship to the conduct that they are trying to prove, which never occurred in this case, which could not occur in this case. I mean, that's what's so silly. Every time I get into arguing this, I think, but it couldn't happen. It couldn't happen. And I mean, that's really the bottom line here. We have a witness with a limited role whose credibility is at issue for the defense. The defense has sought to put it at issue with respect to planting evidence. We have proven conclusively and consistently, without any ability to refute it at all by the defense, that he could not do what they had been desperately trying to prove he did. Could not and did not. All right. So whatever he is, and as far as I can tell, none of it's good, but whatever he is, he couldn't do it. So what are we talking about? What are we going to bring in front of this jury? What is the theory of relevance here? What are we doing? We're going to bring in all of this extraneous stuff to impeach a witness whose credibility is established by other people with respect to this one point. And that's all we're doing. In other words, we're inflaming the passions of the jury, introducing irrelevant or at best collateral evidence to distract them from their duty as to an issue that is resolved by other evidence. That's all we're doing.
Isn't the issue broader? I mean, doesn't the language in In re Anthony P., despite the unique facts of that case, aren't I required to allow broad latitude in cross-examining regarding bias, and in particular racial bias?
Your Honor, I mean, we have argued this previously, but no. Yes and no. Excuse me, yes and no. When there is an opportunity for a witness to have fabricated charges, when there is an opportunity for a witness to have done what they allege, yes, wide latitude should be permitted. And because in that situation, the opportunity combined with the motive adds up to something. You don't have that situation here, Your Honor. That's why Anthony P. is Anthony P. That's why Mascarenhas is Mascarenhas. In both of those cases, it is not inconsequential that it is a one-on-one case where the witness could very well do what they were alleging. And so the ability to prove a motive to do what they had the opportunity to do is an entirely different story. But that's apples and oranges, because in this case, the witness could not have done what they are attempting to prove with this evidence he did. That's the point. And so what we're really left with in terms of relevance, Your Honor, is collateral impeachment. The fact that we have something in the record does not, in and of itself, mean that rebuttal of that evidence comes in. For example, if I'm testifying in a burglary case and I'm a victim of a burglary, and I say, and by the way, the Yankees won the pennant in *55, and I'm wrong, does the defense get to rebut that by putting on extrinsic evidence that the Yankees didn't win the pennant in '55? No. I mean, that's an extreme example, but it makes the point. The fact that there is something in the record in and of itself doesn't mean we get to start slopping into the record extrinsic evidence, especially when it's so inflammatory. This evidence can be characterized no other way but incendiary and inflammatory. But it is definitely collateral. It is so collateral. It goes to impeach the question posed to Detective Furman as to whether he used a racial epithet in the last 10 years. And lo and behold, 9 years and 11 months before he made that statement, we have the bulk of the racial epithets being used. And I think that there is, to the extent that there is any relevance, that people have offered in their moving papers, and we reiterate the offer now, to stipulate that between 85 and 87, Detective Furman used the racial epithet in question. And that's the value of that evidence. That's it, Your Honor. That's it. It is collateral impeachment of a non-material point in the witness's testimony as to a witness whose testimony the court has seen. But again, this is not Anthony P. We cannot divorce the latitude the court gives to cross-examination from the facts of the case. To do that would stand every ruling on its head. Anthony P., the court in Anthony P. confronted one situation that is a vastly different situation than that confronted by this court. This court confronts a case with overwhelming corroboration, a case where there is no opportunity for the witness to have fabricated in the manner alleged. In Anthony P., there was all the opportunity. And hence, when they had evidence of motive, it was improper to exclude it. A very clear-cut case. But the facts in the case have to determine the outcome in terms of the ruling. And so, yes, I do think that the latitude that the court permits in terms of cross-examining as to bias should be governed by the nature of the case, by the facts of the case, by what impact that witness has. Are we to turn a case on its head because a witness who has a small part of the case has a lurid past? Is the defense entitled to do that? Is the defense entitled to take a case, turn it upside down, turn the jury away from all of the evidence and say, look at that. Oh, but look at that. And that's what they'll do. That is what they will do. They already have the ability to do that to some extent. I'm asking the court to not let it go completely out of hand. Now, I think that every trial in California could be turned on its head in this manner. I mean, but I think it is clear, and I think that the facts in the Anthony P. case make it clear that we don't have the same situation. I know that the court is sensitive to the problems that are going to be engendered by the admission of such testimony, but it's not enough. It's not enough to split the baby, Your Honor. You know, when you split the baby dies. And sometimes, it has to be a little bit more. Sometimes you just have to come down on one side. And I submit to the court that this is one of those times. The defense does have the Kathleen Bell incident and Andrea Terry to back that up. The defense will have the opportunity, if they take the stipulation, to argue from the Calgic instruction. The people will have stipulated that Detective Furman lied. That's a lot. That's not a little. They will stand up with the Calgic argument, the Calgic instruction that they know the court's aware of, a witness willfully false, and they can argue everything they need to argue from that with the people's stipulation to the fact that he used that racial epithet. And that is the attention and the time, at most, that this issue deserves. But to turn this into the mini-trial of Mark Furman in the context of a murder case where his credibility has already been resolved as to the issue that the defense is interested in would be a travesty. We need to keep this jury focused. This is a tired jury, and a jury that has been here way too long. We've all been here way too long. And Mark Furman and the content of those tapes is the subject for another day and another forum, and it clearly will be. It's clear to everyone that it will be. This will not be swept under the rug. We have no fear of that. But this is not the place to take care of that. There is nothing good that can come of the interjection of a very serious social issue into a murder trial where it has no relevance. It is manipulative, it is crafty, it is cunning, but it is not proper. It is not relevant. It is not the way to prove a murder case, and it's not the way to defend a murder case. It is nothing but the very blatant attempt to inflame the jury, distract them from the evidence, mislead them, confuse them, and make sure that they do not look at the proof and the properly admitted evidence in this case. I want to remind the court, because we have heard all day about the defendant's right to a fair trial, the victims have one too. Nicole Brown's family deserves to see this case tried on the facts and the evidence that is relevant to the proof of the murders that were committed in this case. Ron Goldman's family has the right to see that this case is kept on track and that this jury is not distracted by inflammatory evidence that does not belong, that is not relevant to this proof of this case. This is a search for the truth, but it's a search for the truth of who committed these murders, Your Honor, not who Mark Furman is. That truth will be sought out in another forum. We have to search for this truth now, and I beg the court to keep us on track and to allow the jury to pursue that search for the truth based on evidence that is properly admissible in this case and relevant to that determination.
Ms. Clark, you say that the court shouldn't split the baby here, and that the court should come down on one side or the other. And you urge me, of course, to come down on the side that you would prefer me to land on. But in the same breath, you also say that you're willing to stipulate that Detective Furman used the term numerous times, and you're willing to agree to the 2.21 instruction that the witness willful or false. So aren't you splitting the baby there yourself in your argument?
In a sense, Your Honor, yes. See, it is my view that as reprehensible as the contents of the tape are, the evidence itself is collateral impeachment. That is so inflammatory it should not come in. And under 352, I think we've made our position very clear that it should not come in at all. Yet I wanted to extend the stipulation because it is a fact that there was a statement in the record for which these transcripts are directly impeaching. And to the extent that they do directly impeach that statement by Detective Furman, that is the only arguable admissibility that I can see, is a stipulation that the word was used. The context in which he uses it is not relevant to this case. And his views on Ethiopia are not relevant to this case. But the fact that the epithet was used when there was a direct denial of that, I could see the court saying, well, you know, Ms. Clark, that's really kind of unfair. He did deny that under oath. He did. He did. And that is why I've offered to stipulate, because I think that is the maximum that should occur. But I think that it would be well within the court's discretion and a very appropriate exercise of that discretion to keep it out altogether, because it is collateral, it is inflammatory, it is not material. So I reasoned it that way. But I do not see that parceling out portions of these tapes to be played will be fair. I do not think it will be fair. I do not think that really any of these tapes should be played for the jury, only because of the arguments that I've made to the court, because I think that we will wind up interjecting inflammatory evidence that really has no relevancy. That's... So I think that's, it was in that spirit that the people offered the stipulation, to the extent that the court thought that an admission should be made of the fact that the witness was impeached in some manner. To that extent, then, we offer the stipulation.
All right. Thank you. Mr. Ullman?
Yes, if I could just have a moment.
Certainly a prosecutor is never in an enviable position upon being confronted with really incontrovertible evidence that perjured testimony was presented by a police officer during their case in chief. But what we're seeing here is an effort to salvage what can still be salvaged from Detective Furman's testimony without conceding that this is a man in whom we can put no confidence whatsoever with respect to anything he said. This is a man who very early in the investigation of this homicide put himself right in the middle of everything. It was Detective Furman who led the detectives over to the Rockingham residence. It was Detective Furman who discovered the Bronco parked askance, even though the photos didn't demonstrate that. It was Detective Furman who discovered the little speck of blood on the car door that provided the probable cause to jump over the wall and enter the premises. And of course it was Detective Furman who finds the glove in a place that is totally inconsistent with all of the other physical evidence in the case, including alleged blood drops leading into the house.
What about Ms. Clark's argument that if Detective Furman had been motivated to frame your client, that perhaps a better place to drop the glove would have been in the kitchen or the bedroom or someplace that a little more logical place, since he clearly had the opportunity to do that as well.
And he well might have if it turned out that that was an opportune place to drop it. We would contend that the location where it was dropped became an opportune place to drop it when he heard what Cato Kalin had to say. What you have heard was an argument that it was just presented facing the wrong way. It should have been presented facing this way to the jury. Because what Ms. Clark is saying is, here are the facts. These are the facts. We know that the glove, that there was only one glove at the Bundy scene. We know that there's blood in the car. We know that those aren't facts. There aren't any facts yet in this case. The facts haven't been determined yet by the jury. And I could get up and present the closing argument that we're going to present to the jury, controverting most of what Ms. Clark said to you was facts. We don't concede those are facts. They're not facts at all. In fact, we have very plausible, credible evidence to controvert virtually every essential fact that is in issue in this case. So we don't have any facts. The facts are going to be determined by this jury. And Ms. Clark's argument to you is simply, well, we have such a strong, incontrovertible case that we know what all the facts are. So if you give this evidence to the jury, somehow this jury is going to go ballistic and ignore all the facts. I'm embarrassed. I have never heard a jury sold as short as it was in the argument that Your Honor just heard. I'm reminded of what Justice Robert Gardner once said about jurors are not some dithering nincompoops who were brought in from a pumpkin patch. We have confidence in the jury's ability to address the evidence in this case. We're not going to be getting up and saying, turn a blind eye to the evidence or turn a deaf ear to the evidence. We're going to argue evidence in this case. And among the evidence we're going to argue is the testimony of Detective Mark Furman, a central witness in this case no matter how you cut it. And I'm not surprised that there's a lot of backpedaling now about how, oh, he's not really a very important witness. What would we expect the prosecution to say when the witness has been proven to be a perjurer? This jury is sitting in judgment on this case simply because they bring some experience of life into the jury box. Because the events that they're going to be asked to sort out, the issues that they're going to be asked to resolve, will be assisted by their life experience. And the existence of 12 people who are brought in from the community to resolve these issues is really the central premise of our whole adversary system. And for us to prejudge the facts and to say we can determine what happened here, and what happened here is not consistent with what the defense is presenting, therefore the defense should be precluded from challenging the credibility of this witness, from showing his propensity to fabricate, it simply takes the case away from the jury. Why even have a jury? And that's certainly a legitimate question to ask in light of the argument that was just made. Why have a jury if we don't have any trust or faith in their ability to sort out the evidence and make their ruling based on the evidence in this case?
Well, why have 352 of the Evidence Code?
We have 352 of the Evidence Code to have a court make a determination of balancing probative value against the risk of substantial prejudice. And we're not afraid of the court making that kind of balance in this case. We are talking about evidence that is highly probative on several scores. It's not just probative on whether there's a likelihood that Mark Furman planted evidence. It is relevant on the issue of whether you believe any and all of his testimony, from start to finish, about every aspect of this case. It is relevant on the issue of habit and custom of police officers. It is relevant on the issue of 1101B in terms of plan, motive, and opportunity. It is relevant to corroborate Kathleen Bell. It is relevant for all of these purposes, and it is highly probative evidence. And it should not be excluded simply out of fear that jurors are going to become dithering idiots when they hear it. They're not. They'll be able to understand the argument that Ms. Clark made, and she's going to have her opportunity to convince this jury that they should still put some stock in what Mark Furman testified to in terms of how he discovered the glove, despite all of the reasons why we should disbelieve Mark Furman. Now, the argument that there's just no way that under these circumstances Mark Furman would have planted evidence or fabricated evidence in this case assumes that the only motive that Furman could have had to do this would have been because he wanted to frame an innocent man. But when you look in context of how Mark Furman explains what he does and how he testifies and how he conducts investigations and how he makes a decision of who to arrest, it tells you a lot about Mark Furman. And I find it speaking loud and clear in the context of that one example where he's playing with blood, where he's squeezing a scab to have fresh blood in order to justify an arrest. Now, if that isn't planting or fabricating evidence, I don't know what is. But in the mind of Mark Furman, it wasn't. In the mind of Mark Furman, here's what he thought it was. He said...
Counsel, I'm 8 feet away.
He says it's putting a criminal in jail. It's being a policeman. So in the mind of Mark Furman, this kind of activity is justified if it's putting a criminal in jail. And it's perfectly consistent with everything he did, that that's what he thought he was doing, even if he was falsifying evidence, even if he was testifying falsely in a number of respects in his testimony presented to this jury. Now, with respect to the specific incidents that we pointed to, that is items 4, 12, and 35, we invite the court to put those in context. Look at the broader context. I mean, what we were doing in this offer of proof was attempting to get right to the essentials that we believe conveyed the idea of what he is saying, what he is advocating, without a lot of extraneous material. But even putting these precisely in the context in which they were spoken, there's no question what he's saying in item number 4. There is no question but that what he is saying is if somebody in Westwood is black, he doesn't belong. And that provides a reason to stop them. And you can make up the reason later on to justify it. What he's saying in number 12 is about, in the context of Laura McKinney's question, don't you need probable cause when he describes stopping someone who is, as he puts it, he says, probable cause, your God. Your God. That's Mark Furman's vision of his role in this process. And we contend there is ample evidence to point to in this record where he was playing God. And it's going to be up to the jury to decide whether that's what was going on or not. And item number 35, same thing. Driving a Porsche that doesn't look like he's got a $300 suit on, you always stop him. I mean, let's not mince words. We know what he's saying. He's saying that based on racial considerations, a police officer can make decisions about who to stop, who to arrest, who to put in jail, who's a criminal, who the good guys are, who the bad guys are. I have been given lots of advice by my colleagues about responding to specific factual issues that Ms. Clark was raising, but I think to do that would detract from my main point. And my main point is that these are arguments to be addressed to the jury. These are not facts. We have a version that we want to argue to the jury, and the jury will determine the facts. And we all need to be reminded that we have a system where we put faith in the jury to determine facts, that we have confidence that they can hear evidence, even evidence that is ugly to hear, ugly to look at, that they can look it in the face, evaluate it for what it is worth, give it the appropriate weight, and then address the evidence and come to a rational conclusion in this case.
All right. Thank you, counsel. All right. Counsel, I think you have presented to me dozens of separate issues. Each one of these incidents is an incident that stands on its own, has to be evaluated on its own, that has to be weighed not only in the 220 credibility of witness context, but also in the context of the 1101B argument, the 1105 argument, and then the court has to make an independent 352 evaluation of each and every one of these individual items. So I'm not prepared to rule now. And I'm going to go back and reread In re Anthony P., because I want to see if I recollect Justice Johnson's opinion the way I recollect it, and if I recollect the facts that were before Judge Burke at the time that he made those rulings. I don't recollect the facts specifically. The interesting thing about In re Anthony P. is that was the first California case that actually, appellate court case that dealt specifically with this particular issue. And I want to go back and revisit that case before I rule, because I think that's clearly the guiding case in the issue that's before the court. The difficulty I have is that this is an unusual situation where you have somebody talking to somebody in the context of the screenplay. So this is not an interview of somebody for the purposes of the life of Mark Furman. This is in a context where somebody is trying to create a work of fiction. But it appears to me that there are instances where it is not role-playing. So the issue is, I have to evaluate each one of these items individually. And the quality of your arguments today, which I will compliment both sides on, has given me a lot to think about. And this is not something that I can rule upon from the seat of my pants. I need to sit down and look at each one of these individual situations and make the appropriate ruling. Unfortunately, that creates a time problem for us all. So why don't we address that issue at this point?
We would expect that Ms. McKinney would be the next witness, and so
Bea,
having
thank
said
you
that, we're
so
mindful of what Your
much.
Honor
I
just indicated
appreciate it.
about
Thank
the
you.
need for time. And I'd like to balance that with the fact that we do have a jury that wasn't here today, and we want to get this case to the jury as soon as possible. Would the court care to indicate to us what is reasonable for you to render a decision in
Yay,
this case?
thank you, thank you,
Because
thank
once you render a
you.
decision, assuming arguendo that a number of these incidents are going to be appropriate, then we have to have the transcripts changed to allow what you let in, to have it redone, to cut the time down between them. And so there's a little bit of hiatus. Well, we have people standing by this afternoon in the laboratory to do that. So obviously, we'll let that go. I mean, I understand. I did not know where we'd be at the end of the day. So we want to move
Well, to
ahead.
show you how optimistic I was, I thought we'd finish this argument this morning.
Well, you did say, well, you were smart enough to decide by 11 o'clock we wouldn't. So that was good. Would the court care to tell us what, because that would really be the next witness if at all possible.
Well, here's the difficulty I have, Mr. Carpenter. You've given me, 60-odd separate incidents. I need to go back and review the record, to look at each one of these individually, perhaps even listen to the tape again. And this is not something that I want to do being rushed.
No, Judge, I want to make this perfectly clear. We're not rushing it. I was just asking so we would see.
But
If
let me ask you this, are there other witnesses, Ms. Menzioni, or any of those other witnesses that we could deal with over the next couple of days? Unfortunately, I have a commitment this evening that will limit the amount of time I have to work on it this evening.
Yes, may I have a moment to talk to my colleagues, Your Honor? There may be, the court's saying that you'd like probably until Thursday. Certainly, we understand that. Let me see what we have, and perhaps, may I get right back to you? Perhaps we can take, I know you want 5:30. Give us about 3 or 4 minutes. Will you do that?
And that is
Let
it.
me stand in recess until tomorrow morning at 9 o'clock. When you have your scheduling plans, let me know, and we'll make that public.
And that was it. So, we got a taste again. We got a bigger taste today than we did yesterday. Horrific things. There's more. There's worse. There's more worse coming. And he says. So, yep, we will check it out tomorrow. Thank you so much for coming out, guys. I really appreciate it. I had Kim Blandino on my first stream, in case you wanted to know, and some Judge Boyd. So, yeah, what is today? Today is Monday. You guys have a great Monday. I'll see you again real soon. Bye, guys.